Good evening. This side Rahul Magan here is a Group Chief Executive Officer, Treasury Consulting. As we speak, Treasury Consulting is a multi-asset, multinational hedge fund. By multi-asset, we actively take positions in multiple asset classes. And by multinational, I mean we take positions in multiple locations across the globe. But having said that, and like I repeated many a times, that we are a proprietary hedge fund. By proprietary, I mean to say no third party. I repeat, no third party can invest capital in our funds. Today, I would like to cover a very important topic in law, which is also known as ex parte. Ex parte, P-A-R-T-E. Actually, there are two parte we have in law. One is called ex parte and one is called by parte. Whether you are in a civil suit, which includes arbitrations, or you are in a criminal suit, which include murder and all these kind of things, there can only be two occasions you can challenge in court of law. Number one is the by parte. The law of natural justice claims that by parte is the best mode to deliver justice. Now, by parte means that both the parties, plaintiff, the man who is putting the case, defendant, the man who is defending the case, both plaintiff and defendant and their legal representatives should be present before the court of law while taking care of this matter. Now, please note that when I'm using a word court of law, I mean to say the whole judiciary. It could be a trial court, it could be appellate, it could be tribunal, it could be special hearing officer, it could be high courts, it could be supreme courts. It means the whole judiciary. This is called by parte. Unfortunately, and in some circumstances, the law of justice go with ex parte. And ex parte means that one party, which is generally defendant, is away from action, which means the plaintiff, the man who is putting up the case, he puts some suit, either civil or criminal, in the court of law, and the court is going one-sided. If you go with the civil procedure courts of various countries, then the most probable reasons which are mentioned as far as the ex parte is concerned is that the summons, or the notices which are issued by the court is not reaching to the defendant. Alternatively, the defendant is irregular as far as the acceptance of summon and notices are concerned. This is one of the most probable reasons the civil procedure courts, CPC of various countries are saying. But unfortunately, in arbitration matters, I have seen that people love ex parte. And today in my video, I would be covering a very beautiful thing which I am noticing as far as the arbitration scenario is concerned, where I personally feel that ex parte should be strictly prohibited. Now, first of all, we need to understand that there is a great myth we are having in arbitration. And that myth is all agreements in the world are subject to arbitration automatically. I'm sorry, guys, until otherwise, I repeat, until otherwise, you are very specific in nature in your agreement. Your agreement not constitute to arbitration agreement. Even if, I repeat, even if merely mentioning of the word arbitration, adjudication, arbitration tribunal, presiding arbitrator, or arbitration panel will not entitled you for arbitration. Please do understand that arbitration is having a judicial decree, be it any country of the globe, because arbitrations are backed up by the respective arbitration laws of respective countries. Example, in case of India, it is Arbitration and Conciliation Act 1996. United Kingdom is having their own respective arbitration act. Singapore having their own respective arbitration act. Henceforth, all the awards, whether it is speaking awards and non-speaking awards, I'm not going in detail about speaking and non-speaking awards, but all awards which are granted under arbitration is having a judicial decree, which means that it can easily be challenged in the court of law. There are provisions regarding invoking of presiding arbitrator. Example, the revoking of arbitration, relieving an arbitrator, appointing an arbitrator outside the jurisdiction of the clause, time allotment for the award, anti-arbitral jurisdiction, and list is very, very long. On the contrary, majority of the contracts are expert agreements. I know you would be thinking that how come expert agreements coming into the picture? Guys, expert agreements means that you are appointing an expert who could be an engineer, who could be an architect, could be a scientist, could be a defense expert, could be a finance expert, could be a legal expert, probably a retired judge, probably some institution, or maybe anything. And the contract is clearly, I repeat, contract is clearly mentioning that his or her award is binding to both the parties. However, you can approach the court of law. It's not that you cannot approach the court of law, but having said that, unlike arbitration, where court of law or the judiciary having unlimited powers, in case of expert agreements, the judiciary having limited powers. If the judiciary feel they can put a stay order on this expert agreement, provided there is a genuine reason behind that. But if the genuine reason is completely missing, everything is explicitly mentioned in an agreement which differentiates between expert and arbitration agreement. In this eventuality, I repeat, in this eventuality, the role of judiciary is very, very limited until otherwise either plaintiff or defendant able to prove that there is an element of fraud. I repeat, there is an element of fraud. So please understand the tactful difference. I repeat, the tactful difference between expert agreement and arbitration agreement. Unfortunately, people not aware. Guys, please do understand that majority of the countries of the globe, except few, they disregard the ex parte either in case of expert agreement or in case of arbitration agreement. And my personal opinion is also that ex parte should be avoided. Ex parte should be completely avoided. This is my personal jurisdiction. If you are plaintiff and second party is defendant, or alternatively second party is plaintiff and you are defendant, if plaintiff is creating an ex parte in an arbitration clause, it might be arbitration tribunal, it might be the appellate court, it might be the high court, or it might be the higher courts. In this eventuality, the first thing you and your legal firm supposed to do is to take an interim relief, rather anti-injunction, rather injunction immediately, because ex parte is strictly prohibited in multiple countries across the globe. Because the reason is very clear: until otherwise both parties are present, both parties and their legal representatives are not explaining their version of the case, and the court is simply giving a judgment based on single party intention, it means there is some messy thing in the system. By court, I mean to say the arbitral tribunal. By court, I don't mean to say the courts, because in arbitration, if you go to courts, then they love bi parte. They don't love single party, which is known as ex parte. Henceforth, if your agreement is either an expert agreement or it is arbitration agreement, it would be better if you're using words like adjudication, sub judice, arbitration, arbitration tribunal, presiding arbitrator, and so many words. It would be very clear that if you write immaculately, I repeat, if you write immaculately that guys, even in the worst scenario, I repeat, even in the worst scenario, ex parte is not allowed. And if either party, party A or party B, is going ahead with ex parte, then this is considered as a violation of the natural justice. And your agreement should be very clear that arbitration tribunal, arbitration, presiding arbitrator, arbitration panel cannot be formed if there is a scenario of ex parte. I once again repeat that there is a hell lot of difference between expert agreement and arbitration agreement. Apparently speaking, both look same, and it is not an easy job to differentiate between both of them because the wordings look very, very similar. However, irrespective of all the complications, irrespective of all the mess, it is the duty of both the parties to read each and every word carefully. Because in case of expert agreement, courts are having limited jurisdiction, while in case of arbitration, courts are having unlimited jurisdictions. Multiple countries have their respective steps to differentiate between expert and arbitration agreement. But in either case, if you confirm that you're going with either, in either case, make sure ex parte is not allowed. Please. This is Rahul Magan from Treasury Consulting Group. Have a great time ahead.